Namaskar, Pranam, Jai Shri Ram. Welcome to the 5th episode on Waqf Amendment Bill 2024, which from now onwards I will be calling it as UMEED, the new name which has been proposed when this bill will be tabled in the Parliament by the Joint Parliamentary Committee. In episode 4, we had run through 14 or maybe 15 amendments out of 44 amendments which have been approved clause by clause by the JPC members. Now I will take you through each of the clauses, beginning with clause 3. Clause 3 was moved by Honorable Members Shri Nishikant Dubey, Shri Tejasvi Surya and Shri Lavu Shri Krishna Devayaralo. Now let us go through what this clause 3 as moved by all these honorable members were proposed. It went for voting. Those in favor were 16 against 10 and hence it was adopted. So now we go through the clause 3 in detail. So let us go back to the consolidated recommendations. Wherein under clause 3 as proposed by honorable members were adopted. Now clause 3, the committee after thorough deliberations on the amendments proposed to existing definitions on the inclusion of new definitions proposed in the clause under various examination, and after taking into consideration the views and suggestions of various stakeholders, justification furnished by nodal ministry are of the view that proposed definitions of the collector, government organization, government property, portal and database and amendments proposed in the bill with the intention to streamline the Waqf property management, reduction in the number of litigations, expanding the scope of beneficiaries of Waqf, etc. Thus, the committee have decided to accept the amendments proposed except for amendments proposed vide clause 3.9. 3.7 regarding the proposed amendments stipulating that only a person practicing Islam for at least 5 years will be permitted to dedicate any movable or immovable property as Waqf, the committee proposes the following amendments to clause 3.9a. In the opening portion for the words any person of any movable or immovable property, the words any person showing or demonstrating that he or she is practicing Islam for at least 5 years of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property. So there should be clear ownership, clear title, no contrivance involved in dedication of such property, which is a very important amendment proposed and which has been adopted. 3.73 regarding the amendments proposed in the definition of Waqf, the committee have observed that the proposed omission of Waqf by user through clause 3.9b of the amending bill have created apprehensions among various stakeholders and the Muslim community at large regarding the status of the existing Waqf by user, which largely includes property used for religious purpose. The committee, in order to evade such apprehensions, proposed that a proviso clearly specifying that the omission of Waqf by user from the definition of the Waqf will apply prospectively. This is very important. Prospectively and not retrospectively. That is, the cases of existing Waqf properties already registered as Waqf by user will not be reopened and will remain as Waqf properties even if they do not have a Waqf deed. Now this is severe dilution in terms of Waqf by user. Majority of land grabbing or disputes have come to the fore because of Waqf by user. However, the committee has thought it fit to not open retrospect old cases of Waqf properties by user, and that too even if they do not have a Waqf deed. This is severe dilution, but then let us see how this whole thing proceeds. This was, however, be subject to the condition that the property wholly or in part must not be involved in a dispute or be a government property. So there is a ray of hope. It should not be a government property. So sometime back, Honorable CM of Uttar Pradesh, Yogi ji, had already said that more than 80% of Waqf properties that too work by user, are predominantly government properties. So naturally, the Waqf deed or Waqf title by user will get relinquished and the government properties will go back to the government. Accordingly, the following amendment to clause 3.9 is proposed. E. The following proviso shall be inserted, namely, provided that the existing Waqf by user property is registered on or before the commencement of Waqf Amendment Act 2024 as Waqf by user will remain as Waqf property except that the property wholly or in part is in dispute or is a government property. So government property, so no longer Waqf by user is applicable. Any other property where a dispute is going on under Waqf by user, that also will be out of the purview of Waqf and it will be left to the litigating authorities and decision makers to clear the litigation and release that properties. Clause 3.7.4 further, as regards the amendments to the definition of Waqf alal aulad, wherein through proposed amendment the scope of benefit will be further expanded for maintenance of widowed, divorced woman and orphan in such a manner as may be prescribed by the central government. The committee, after considering various submissions, recommend that the intention of the Waqif should be taken into account while deciding the beneficiaries of a Waqf. Accordingly, following amendment to clause 3.9c is proposed. So, C in subclause 5, after the word orphan, the words if Waqif so intends shall be inserted. We now move on to the next clause, which has been moved by various honorable members and then adopted after majority vote. The next clause moved and adopted by the JPC is clause number 4. This clause with amendments was moved by Shri Brijlal, Shri Lavu Shri Krishna Devaya Ralu, Shri Dileshwar Kamet and Srimati Aparajita Sarangi. Now, what are these clauses and what were the amendments proposed? The committee, after thorough deliberations on the amendments proposed to defining certain conditions of creating a Waqf, accept the amendment defining the condition of making a Waqf that only a lawful owner of a property can dedicate it as Waqf. So, very important, lawful owner of a property only can dedicate it as a Waqf and not anybody who's one fine day wakes up and says that this property is Waqf just because I am saying it. Clause 4.7.2, as regards the conditions stated for creation of Waqf alal aulad, the committee have proposed further amendments. Accordingly, following amendment is recommended in clause 3A2. After the word Waqif, the word or any other rights of persons with lawful claims shall be inserted. 4.7.3, as regards the proposed new section 3B1 and 2 regarding filing of details of every registered Waqf property on the portal and database within 6 months and the details that need to be filed, the committee, while accepting list of details to be filed on the portal as given in clause 3B2, are of the opinion that a window should be kept open for filing of details of registered Waqf property even after the lapse of the period of 6 months in genuine cases by making following amendments to the proposed section 3B1 under clause 4. Provided that tribunal may, on an application made to it by the Muttawali, extend the period of 6 months under this section for such period as it may consider appropriate, if he satisfies the tribunal that he had sufficient cause for not filing the details of the Waqf on the portal within such period. So, extension only after there is a sufficient cause for not filing the details. 4.7.4, on the new section 3C1 dealing with wrongful declaration of Waqf, the committee accepts the recommendation that any government property identified as or declared as Waqf property shall not be deemed to be a Waqf property. Nonetheless, the committee have received strong objection on the proposal of delegating the power of determining whether a property is a Waqf property or government property to the collector. The committee feel that in such a scenario, the decision of appointing an official to conduct an inquiry in cases of wrongful claims on government property by Waqf board should be left to the state government. So, it has now become a state chapter. The committee therefore recommend the following amendments to the proposed section 3C2, 3 and 4. In clause 4, in the newly proposed section 3C2, after the words government property for the words the same shall be referred to the collector having jurisdiction will make such enquiry as he deems fit. The words state government may by a notification designate an officer above the rank of collector herein after called, the designated officer who shall conduct an enquiry as per law shall be substituted. In clause 4, in proviso to section 3C2, the word collector to be substituted with designated officer. So, apprehensions of collector being given sweeping powers have been addressed by provision of a designated officer who can be above the rank of collector also. In clause 4 in proposed section 3C3, the word collector be substituted with designated officer. Again in clause 4 in the proposed section 3C4, the word collector to be substituted with the word designated officer. We shall now move on to the next clause. Clause 6 was moved by the Honorable Member of Parliament Shri Saikia ji, and it was adopted with a majority vote. Now what is clause 6? Clause 6 is 6.7. The committee, after comprehensive deliberation on the proposals outlined in the clause under examination, acknowledge the merit in the proposed amendments wherein detailed procedure with defined timeline for publication of list of Waqf in official gazette, uploading of list on the portal and mutation in land records has been brought out. So a defined timeline has been introduced. These amendments ensure transparency and accountability in the management of Waqf properties, hence accepted by the committee, except for amendment proposed in subsection 2 of section 5 through clause 6C, which proposes insertion of a new subsection 2A. It is recommended that the time period proposed for uploading the notified list of Waqf on the portal and database after its publication in the official gazette by the state government may be revised from 15 days to 90 days. Accordingly, the following amendment is recommended in clause 6C. 2A. The state government shall upload the notified list of Waqf on the portal and database within 90 days from the date of its publication in the official gazette under subsection 2. The next clause was clause 7, which was moved by Honorable Member Srimati Aparajita Sarangi, and it was adopted by majority vote. 7.7.1 The committee support the extension of time period for instituting a suit in the tribunal or any dispute regarding the nature of Waqf from 1 year to 2 years from the date of publication of the list of Waqf, as the amendment ensures fair access to justice. However, the committee are of the opinion that there can be delays in filing suits in such cases due to various reasons, and thus recommend that the tribunal shall have power to condone delays beyond the proposed 2-year period for entertaining applications regarding dispute over Waqf properties on a case-to-case basis. So this has become discretionary. Accordingly, following amendment to clause 7A4 is proposed. For the second proviso, the following proviso shall be substituted, namely, provided further that an application may be entertained by the tribunal after the period of 2 years specified in the first proviso if the applicant satisfies the tribunal that he had sufficient cause for not making the application within such period. 7.7.2 The other proposed amendments in clause 7 are merely consequential, therefore the committee accepts them as it is. Clause 9 was moved by Honorable Member of Rajya Sabha Srimati Medha Kulkarni ji, which was voted by majority vote and hence adopted. 9.7 The committee, after thorough deliberation upon proposals made in the clause under examination, including the views, suggestions of stakeholders and the justification given by Ministry of Minority Affairs, find that considering the statutory nature of the Central Waqf Council, inclusion of 2 non-Muslim members will make it more broad-based and promote inclusivity and diversity in Waqf property management. The bill has further emphasized upon the participation of Muslim women in the council, and the committee accepts all the amendments proposed under the clause. However, it has been brought to the knowledge of the committee that the presence of non-Muslim ex officio members may result in fulfilling the requirement of the proposed amendment, whereas this may go against the intent of the proposed amendment. Hence, the following amendment is proposed in second proviso to clause 9. Provided that the two members appointed under this subsection, excluding ex officio members, shall be non-Muslims. Clause 11.7. The committee, after thorough deliberations, find that the composition of state Waqf boards has been expanded to include two non-Muslim members and ensure broader representation from Shia, Sunni and backward Muslim communities, which will promote inclusivity and diversity in Waqf property management. The committee feel that non-Muslims can be beneficiaries, parties to dispute or otherwise interested in Waqf matters, which justifies their inclusion in the administration of Waqf, and the committee accepts the amendments proposed under this clause. However, it has been brought to the knowledge of the committee that the presence of non-Muslim ex officio members may result in fulfilling the requirement of the proposed amendment, whereas this may go against the intent of the proposed amendments. Hence, following amendments are proposed in clause 11. The proposed subsection 1e of section 14 be substituted as given below. Joint Secretary of the state government dealing with Waqf matters member is an ex officio. The second provision to subsection 1 of section 14 be amendment as given, provided further that two members of the board appointed under this subsection, excluding ex officio members, shall be non-Muslims. So, inclusion of non-Muslims into the Waqf board and the Waqf council, as well as representation from Shia, Sunni and backward Muslim communities, is a major step forward for more inclusivity and diversity. Amendment to clause 12 was moved by Honorable Member Shrimati Medha Kulkarni ji, which was voted by majority in favor and hence adopted. 12.7.1. The committee, after thorough deliberations and various suggestions from stakeholders plus justification by Ministry of Minority Affairs, find that this clause would ensure that individuals with a clean legal record can serve on the board, improving accountability and trust. Hence, the committee accepts the amendments proposed under the clause. 12.7.2. Further, the committee are of the opinion that the condition for disqualification given in section 16A, that is, he is not a Muslim and is less than 21 years of age, is incongruous with other clauses provided in the bill. Therefore, the committee recommends the following. 1. For clause A, the following clause shall be substituted, namely A, he is less than 21 years of age. 2. After clause A, the following clause AA shall be inserted, AA, in case a member under clause C of subsection 1 of section 14 is not a Muslim. Amendment to clause 18 was moved by Honorable Members Shri Dilip Saikia and Dr. Radha Mohan Agarwal ji. 18.7. The committee, after thorough deliberation with various stakeholders and considering replies submitted by Ministry of Minority Affairs, are of the view that execution of Waqf deed, now this is important, for the new Waqf would strengthen the legal status of such Waqf and reduce the number of litigations owing to the absence of written documents relating to a Waqf property in future. The measures introduced to inquire into the genuineness and validity of a Waqf would further reduce disputes and claims on grounds of wrongful declaration of Waqf. Hence, the amendment is accepted as it is. However, the committee, while examining the proposed subsection 10 of section 36, which states that no suit, appeal or other legal proceedings for the enforcement of any right on behalf of any Waqf which have not been registered in accordance with the provisions of this Act shall be instituted by any court after the expiry of a period of 6 months from the commencement of the Waqf Amendment Act 2024, feel that the time period may be increased to give adequate time to all stakeholders to represent. Therefore, the committee, after deliberation, recommended that instituting of suit shall be allowed beyond the period of 6 months, and accordingly the following proviso to subsection 10 of section 36 be inserted, provided that an application may be entertained by the court in respect of such suit, appeal or other legal proceedings after the period of 6 months specified under this subsection if the applicant satisfies the court that he has sufficient cause for not making the application within the stipulated time. So, this is an important amendment, and in the larger interest of proper registered Waqf deed or agreement or document to be in place. Clause 31 was moved by Honorable Member D.K. Arunaji. 31.7, the committee find that section 67 subsection 4 is being proposed to be substituted with the first provision of section 67 of the Principal Act wide clause 31 of Amendment Bill. Thereafter, in the second proviso of section 67 subsection 6, the omission of the words "and the order made by the tribunal in such appeal shall be final" shall be omitted. So, mark the words in italics in the commas. Order by the tribunal shall be final, which has been the major bone of contention in so many disputes even today, shall be omitted. These amendments are aimed at providing any person aggrieved by the order made by the board under section 67(2) a chance to appeal and utilize the various avenues of appeal for justice available. Thus, the committee appreciates the option of providing further scope for availing justice to the aggrieved person and decided to accept the amendment proposed under the clause. However, the committee recommends that the period of appeal shall be increased from 60 days to 90 days and accordingly propose the following amendment in clause 31A. Any person aggrieved by the order made under subsection 2 may within 90 days from the date of the order appeal to the tribunal. Amendment to clause 33 was moved by Honorable Members Shri Dilip Saikiaji and Shri Naresh Maskeji. 33.7. The committee examined the clause 33 and note that clause 33 of the bill seeks to amend section 72(1) relating to annual contribution payable to board, replacing the contribution to 5% in place of 7%, while in section 72(7) the words "and the decision of the board thereon shall be final" shall be omitted. In context of the reduction in annual contribution to the Waqf board by the Muttawali of a Waqf property, the committee are of the opinion that with the proposed strict accounting and auditing of Waqf, the funds available with various Waqf boards even at 5% contribution would be reasonable, and at the same time the individual Waqfs will have more funds at their disposal for pious, charitable and religious purposes. However, the committee do not rule out instances where a particular board may face financial crunch. The committee therefore feel that a flexible upper limit may be envisaged depending upon the financial situation of a board. Hence, the committee recommend the following amendment in clause 33A. A. In subsection 1, for the word 7%, the word 5% subject to a maximum amount as prescribed by the central government shall be constituted. Regarding the amendment proposed under section 72(7) pertaining to the omission of the words giving finality to the decision of the board, the committee note that it is a consequential amendment aimed at providing the aggrieved with an opportunity to challenge the decision of the board, thus increasing the ambit for attaining justice. Hence, the committee decided to accept the amendment proposed under the clause. Amendment to clause 35 was moved by Honorable Member Shri Sanjay Jaiswal and Shri Gulam Ali, and it was adopted through a majority vote. 35.7. The committee, after thorough deliberations upon the proposals made in the clause under examination, including views, suggestion of stakeholders, justification given by Ministry of Minority Affairs, find that the proposed amendments, including declaration of any tribunal as Waqf tribunal, introduction of the provision of appeal to High Court directly, and change in the composition of the tribunal would expedite disposal of pending cases, considering that as many as 19,207 cases are pending in Waqf tribunals. Thus, the committee endorsed the amendment proposed in the clause except for the provision relating to the composition of the tribunal. The committee are of the opinion that the composition requires revision to incorporate a member having knowledge of Muslim laws and also to make a tribunal a 3-member body rather than a 2-member body. The following amendments are recommended in clause 35. In clause 35, in subsection 4, after point B, point C is inserted. C, one person having knowledge of Muslim laws and jurisprudence be a member. 2. The first proviso in clause 35C under subsection 4 is omitted. 3. The second proviso in clause 35C, the word further after the word provided is deleted. Amendment to clause 36 was moved by Honorable Member Shri Tejasvi Suryaji. 36.6. Considering the high pendency of cases with the Waqf tribunals, the committee are of the firm opinion that the said amendment providing a timeline for settlement of disputes would expedite disposal of cases. However, the existing provisions of the law states that whenever an application is made to a tribunal for the determination of any dispute, question or other matter relating to a Waqf, it shall hold its proceedings as expeditiously as possible and shall as soon as practicable on the conclusion of the hearing of such matter give its decision in writing and furnish a copy of such decision to each of the parties to the dispute. The committee are of the view that in the existing section, ample emphasis has already been given to earliest disposal of cases by the tribunal. Therefore, it may not be necessary to fix a time period for the disposal of the cases by tribunal. Accordingly, amendment to clause 36A is given below. Clause 36 stands omitted. Amendment to clause 37 was moved by Honorable Member Srimati D.K. Arunaji. 37.9.1. The committee examined clause 37 seeking to amend section 91 of the Principal Act and agree with the replacement of repealed Land Acquisition Act 1994 with the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. The committee also accepts the amendment wherein any order passed under section 77 or section 78 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 is not declared void if the board is not given an opportunity to be heard. Rather, the said order shall be kept in abeyance relating to portion of the property claimed by the board and assigning collector to hear the parties and make the order within 1 month. 37.9.2. However, the committee, after hearing all the stakeholders, feel that the proposal to reduce the time period given to the board to appear before the collector on receipt of notice of acquisition of a Waqf property from 3 months to 1 month would not be reasonable time for the board to plead to the proceedings under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Hence, the committee recommends retaining the 3 months period. Accordingly, clause 37A2 is omitted. Amendment to clause 41 was proposed by Honorable Member Shri Nishikant Dubeji and it was adopted by majority vote. In view of the deliberations with various experts and stakeholders and submission of various government ministries as well as those of Ministry of Minority Affairs, the committee concur with the desirability of the proposed omissions of section 107, 108 and 108A wide clause 41 of the amendment bill, as these are necessary to reduce litigation and simplify the process of recovering Waqf properties, thereby facilitating legal harmonization of the Waqf Act 1995 with other laws and avoiding overlapping with the various acts. So, here the stress is to reduce litigation and simplify process of recovering Waqf properties. Notwithstanding the said desirability, the committee also empathized with the concerns expressed by multiple stakeholders regarding the potential of assertions of adverse possession resulting from retrospective applicability of the Limitation Act 1963 emanating from the current formulation of the clause 41. In this regard, the committee do take note of the assurances of prospective application of the omission of section 107 by Ministry of Minority Affairs. Thus, for removal of any doubts whatsoever, the committee have redrafted the proposed amendment as follows. A new clause 40A is proposed as given. 40A section 107 of the Principal Act be substituted, namely, on and from the commencement of the Waqf Amendment Act 2025, the Limitation Act 1963, 36 of 1963 shall apply to any proceedings in relation to any claim or interest touching upon immovable property comprised in a Waqf. Clause 41 is amended as given. Section 41 sections 108 and 108 of the Principal Act shall be omitted. We now come to the end of this episode, where we have gone into details of various amendments which are adopted clause by clause and now form part of the JPC recommendations and the proposed amended bill, which is called as UMEED Bill, to be tabled in the Lok Sabha. It should happen anytime this week or in the coming week. At the same time, it would be worthwhile to go through the dissent and comments on the Waqf Amendment Bill proposed by various members of the JPC committee. So stay tuned till next episode, wherein I would be going through clause by clause dissent notes by various members of the JPC and why they are opposing the Waqf Amendment Bill. Thank you for being with us. If you liked this video, please press the like button. Also subscribe to my channel and don't forget to press the bell icon so that you continue to receive all future updates. Till then, goodbye from now. Thank you. Jai Shri Ram.